So let's now turn to the second principle of international water law, and that's the obligation to prevent causing of significant transboundary harm. So I will say a few words about this principle, and then we have the lunch break. So as I said earlier, the no harm rule in international water law is basically a variation of the no harm rule as exists in international environmental law more generally. So it's always traced back to this trail smelter arbitration between the US and Canada, which led to an award in 1941. This case was about air pollution. It's about a smelter situated in Trail in British Columbia in Canada. A smelter which produced lead and zinc. And as you can imagine, in those days, the smelting and the melting process, lead and zinc, that led to a lot of pollution, especially polluted fumes, fumigations. So this smelter was situated in Trail in Canada, and as you can see, the fumes, they crossed the border into US, and they caused some considerable damage to the agriculture there. To crops and timbers, wood that was produced there in the US part of the border. So then, the US and Canada, they took the dispute to arbitration, and this is a very famous quote from the award. No state has the right to use or permit the use of its territory in such a manner as to cause injury by fumes in or to the territory of another state or the properties of persons therein, when the case of serious consequence and injury is established by clear and convincing evidence. So this was about fumes, toxic fumes, from one side of the border to the other. But the same principle is applied more general to any form of harm caused in or by one state against its neighbor. It's interesting maybe what the result was of this particular arbitration. So the smelter actually could continue its work after the award was produced, but it had to take measures to mitigate the harm caused to the farmers in the US. If harm would nonetheless be caused, despite appropriate measures being taken by the smelter factory, then compensation should be paid to the farmers, even in the absence of a specific wrongful act, because the smelter would then comply with its due diligence obligation to try and mitigate the harm. But this is very common in international environmental law, that sometimes you have to pay compensation even though you did not really act in breach of any particular international law. It's just that somebody has to pay for the damage. So this principle that was sort of introduced into our world by the award, the Trail Smelter Award, then was picked up and became a general principle of international humanitarian law. You can find it in the Declaration on the Human Environment. That's the outcome document adopted at the Stockholm Conference in 1972. That was the first UN organized conference on the environment, and that is really where international environmental law took off. So in this Declaration on Human Environment, you find the famous Principle 21, which says that states have the sovereign right to exploit their own resources pursuant to their own environmental policies. That's the right, but they also have a responsibility to ensure that activities within their jurisdiction or control do not cause damage to the environment of other states. So that's the last part of this principle is the no harm rule. So there's a lot to say about it. States have the responsibility to ensure that activities within their jurisdiction or control. So very often the harm is not caused by the state directly, but by corporations or human beings that operate on the state's territory. But that doesn't matter, and still the state breaches the no harm rule. They must do whatever they can to ensure that such activities do not cause damage to the environment of other states. So it works in a transboundary sense. If activities on the territory of one state cause damage to the environment of that very same state, then international law is not interested. There must be a transboundary element to it. So that's principle 21. And then what happened? Then this principle was further. Why is it not showing? Oh yeah. Wow, you've learned so much already. It's amazing. All this you already know. Yeah. So the no harm rule was further developed by the International Law Commission in its draft articles on the prevention of transboundary harm from hazardous activities. So these articles, as I said earlier, they also apply to activities that are not strictly speaking prohibited by international law, but which involve the risk of causing significant transboundary harm in some way. So in a way it's very akin to the general duty of care that exists in domestic legal systems. So sometimes a state commits a tort even when it's not really acting in breach of a specific provision of domestic, European or international law, but it's just acting careless towards its citizens. So it's breaching a general duty of care. This is a bit similar. So what does harm mean? Harm means injury caused to persons, property or the environment. So it doesn't have to be felt by the state itself. It can also be felt by specific people or a group of people or the environment. And transboundary harm means harm caused in territory of or in other place under jurisdiction of control of one state and then felt in the other. For example, if harm is caused in occupied territory, then and it's felt in the neighboring state, then the occupying state is responsible. The state of origin shall take all appropriate measures to prevent significant transboundary harm, or at any event minimize the risk thereof. So that again tells us it's a due diligence obligation, so it's not an obligation of result but of conduct. The state must take all appropriate measures. And that, well, you know, a state is an abstract entity, so that basically means that people that work for the state have to regulate it properly, so make the proper domestic law. And also enforce that domestic law. And part of this duty of care, this due diligence obligation, is the making of an environmental impact assessment in relation to any big project that might negatively affect the environment. So for the principle of equitable and reasonable utilization, we can refer to the Gabčíkovo-Nagymaros case. But for the no harm principle, we have a different case. That is the ICJ's case between in a dispute between Argentina and Uruguay on the pulp mill. Pulp mills. Pulp mills are factories that produce pulp. That's basically paper. So paper producing factories. And that requires a lot of water to produce paper. I don't know if that's the same in Turkey, but in the Netherlands it's very fashionable these days to have a paperless meeting and paperless courses and so on. So all our syllabus are now available digitally rather than in printed form. That is to protect the environment, not only to protect the trees, but also to limit our consumption of water, because it takes a lot of water to produce one piece of paper. So the pulp mills case. What's the pulp mills case about? It's about these factories producing paper that were situated on the border of the river Uruguay, and they were adding some kind of chemical to the water to enhance the quality of the paper, and some of that ended up in the river Uruguay and affected the other state, so the neighboring state. But then the ICJ concluded that the harm did not reach the threshold of significant harm, so no wrongful act was committed. Yeah, because a little bit of harm is okay. But this case we always refer to as an example of application of the no harm rule in the context of international water law. As Article 5 does, so does Article 7 have a procedural aspect to it. So the ICJ in the pulp mills case recognized the central role of procedural rules in the effective implementation of the substantive rules of international water law. And more particularly, the environmental impact assessment process is vital to reaching an equitable and reasonable utilization. So it linked these procedural principles both to the no harm rule and to the principle of equitable and reasonable use. So how does that work? So there's a due diligence obligation not to cause transboundary harm. You have to do everything you can to avoid the causing of transboundary harm. And that also requires that you follow a certain procedure. So you have to conduct an environmental impact assessment before you allow corporations to build big infrastructural projects near or on the banks of the river. You have to consult with your neighbor, you have to inform your neighbor, and so on, provide it with information. So all these procedural principles, they also feed into the substantive principle of no harm. So if you have complied with all these procedural principles, in a sense you have shown that you were serious, sincere in trying to take all appropriate measures to prevent causing of harm. But it's still possible that you have met with all your procedural obligations, so you've conducted the environmental impact assessment, you've shared the results with your neighbor, you've informed your neighbor, you consulted with your neighbor, you provided access to public participation to people that had a particular stake in the production of the factory or whatever. But still, significant harm is caused, and still it can be concluded that you could have done more. So how does the no harm principle figure in the Water Convention? Well, you find it in Article 7. which basically reads that states must take all appropriate measures to prevent causing of significant harm to other watercourse states. Significant harm, and that is harm, according to the ILC's commentary to this article, that's sort of in between trivial and substantial harm, and that is significant harm. And this principle, much more than the equitable and reasonable use principle, is based on the idea of sovereign ownership of the river. That you can do, it's based on this idea that you can do whatever you want with your part of the river as long as you do not cause significant harm to the part of that very same river belonging to the other states. I don't know if it's helpful, but when I teach international water law, I sometimes refer that, compare to two children, or it could be anyone, eating an ice cream together. So, of course, you can say this bowl of ice cream is mine and that bowl is yours, but then, of course, they influence each other in all various ways. The obligation not to cause harm relates both to the quality and to the quantity of freshwater resource. So people often think of pollution, so almost all the case law is about transboundary pollution, but you can also cause significant harm by extracting disproportionately large quantities of water from the river, so that the other states can no longer use the water for agricultural purposes. That's also a kind of harm. So it doesn't have to be related to the quality of the water, the polluting of the water. It can also relate to quantity. So how do you negatively affect the quantity of the water? Dam projects, partial diversion of the river for irrigation purposes, think of the Rio Grande scenario, or extraction of fresh water for drinking. How do you affect the quality of the water? Well, by polluting it, but also a dam might also negatively affect the quality of the water, because well, I'm not an expert, but there's a lot of sediment in the water, and some dams can obstruct this sediment, and also they can make it impossible for fish to pass through the dam. So then the fish cannot continue seawards. So they stay in the upstream part of the river, and fish can also affect both negatively but also positively the quality of the water in the river, and more generally the ecosystem of the river. For example, if a river is very popular because of the fish that swim there, then you cause harm to the river by not allowing the fish to continue downstream. Now I want to put to you something that I find interesting, because I'm an international environmental lawyer, and that is whether the no harm principle can also be applied in an intergenerational sense. So if you look at Article 7 of the UN Watercourse Convention, the way it's formulated, it really applies in an intra-generational sense. So it applies within the present generation. But why could we not envisage a no-harm rule that would protect the future generations from harm caused by the present generation? That doesn't exist yet, but it's not such a crazy idea. And so then the future generations of Turkish people would be protected from harm caused by us, the present generation of Turkish people. But we don't have that kind of no harm rule yet. So finally, before we have lunch, I want to return again to my case, the great Ethiopian Renaissance Dawn case. So about these treaties, I'll say a bit more about them now. So as I said earlier, the first one is a treaty between Ethiopia and the United Kingdom. But then it's alleged that Egypt is successor to the United Kingdom, and so is the Sudan. According to the 1929 treaty, so this one, Egypt has a veto power over I'm mistaken. According to this treaty, the UK, now succeeded by Egypt, has veto power over projects on the Nile done in Ethiopia, on Ethiopian territory, if Egypt decides that such projects would cause harm to its Nile water interests. And that's what it says here. So Ethiopia needs to ask for permission from Egypt before it can, for example, construct the great Renaissance Dam. Egypt, of course, rejects this agreement, saying it's not binding because Egypt cannot be seen as the successor to the UK. But Egypt, of this treaty, claims that it's valid and binding, and that indeed it did succeed the UK. And so Ethiopia should have asked for permission. So what does this treaty between Egypt and Sudan then add? Egypt again has veto power over projects on the Nile conducted in Sudanese territory, if Egypt decides that any such project would cause harm to its Nile water interests. So the same rule that earlier applied between Egypt and Ethiopia also applies between Egypt and the Sudan. So now we turn to the modern days. The Cooperative Framework Agreement, as I said earlier, was meant to replace those colonial treaties. And it's easy to imagine why Egypt would prefer the colonial treaties, because under the colonial treaties, for any water management project in Sudan or in Ethiopia, Egypt has to give consent. Those were the rules in the colonial era. So the British really preferred the Egyptian interest over those of the Sudan and of Ethiopia. So Ethiopia wanted to replace those old rules with new rules, and that is why it took the initiative to conclude this cooperative framework agreement. But the problem is that Sudan and Egypt vehemently opposed to this cooperative framework agreement and will probably never ratify it. And that makes it a bit useless, and also it makes it difficult to reach the required number of ratifications for its entry into force. But even if it would enter into force without the participation of Egypt and Sudan, is useless. But this cooperative framework agreement, it does have the no harm rule in it, in Article 5. And now basin states shall, in utilizing the Nile River system, water resources in the territories, take all appropriate measures to prevent causing of significant harm to other basin states. This is basically a copy-paste of the UN Watercourse Convention. And it's interesting that very much like the UN Watercourse Convention, a preference is given to the equitable and reasonable use principle, because the no harm rule has to be applied having due regard to the equitable and reasonable use principle. So in that sense, it also follows the UN Watercourse Convention. And then the Declaration of Principles on the Ground Ethiopian Renaissance. As I said, it's not a treaty, but it's a sort of political declaration signed by Sudan, Egypt, and Ethiopia, so all the relevant players this time. So this declaration has a reference also to the no harm rule, and that's this. The free countries shall take all appropriate measures to prevent the causing of significant harm in utilizing the Blue Nile. Where significant harm nevertheless is caused to one of the countries, the state whose use causes such harm shall take all appropriate measures in consultation with the affected state to eliminate or mitigate such harm and maybe provide compensation. So it's interesting that in the declaration you find this rule formulated in this way, because supposedly then, at least in a political sense, also Egypt and the Sudan agree with this rule. I already referred to this a little bit, but to conclude, I just wanted to finish with the relationship between the two, the equitable and reasonable use principle and the no harm principle. I think it is fair to say that in general, the equitable and reasonable use principle has priority over the no harm principle. The UN Watercourse Convention says this explicitly in Article 7, Paragraph 2, but many specific agreements, like the 2015 Declaration on the Great Ethiopian Renaissance Dam, also see it this way. If you look at ICJ case law, it's not so clear. So in the Gachikov and Aguimaros case, the equitable and reasonable use principle took primary stage. But in the 12 Mills case, the no harm rule was much more prevalent. But that could be because in both litigations, eventually it was about the interpretation of a particular bilateral treaty. But the prioritization is very important, because if the equitable and reasonable use principle takes priority, then the state may have to bear harm, even reaching the degree of significant harm, perhaps with appropriate compensation being provided, to allow another state to use the river in a way that maximizes its benefits, that's equitable and reasonable. So I think, to conclude, it's probably a better view to see that the obligation to prevent harm, the no harm rule, is a factor that to be considered in whether a state's utilization of the shared watercourse is equitable and reasonable. So the principle is equitable and reasonable use, and the obligation to, the due diligence obligation to prevent the causing of significant harm is then part of this search for a balance between different water uses. So this is all you need to know about international water law, and I think it's now time for lunch, yes? There's about 3 minutes left, so if you have questions, that's also okay. It's up to the organization what we do now.
Yeah, we have. If you have questions, you can ask.
You can also ask them at lunch, of course.
If you don't, we can go to lunch.
Okay. Thanks for your attention.
Thank you.